throughout the state. I am not a lawyer, but I do watch Law and Order. And I am not giving legal advice. Please consult qualified legal counsel. I particularly recommend that as you work in these ordinances, you find someone experienced with developing wind energy ordinances. It is a specialty, and we've seen a big difference in how those things move forward in various communities across Michigan. Now to the commissioners here today, I would say I fully understand the pressure of being asked to say through your zoning ordinance either yes or no to a wind development. It is a thankless task that you don't anticipate when you volunteer to serve your neighbors on the zoning or planning board. The good news is, I think, with the solution that I recommend and the things I propose, that if you use the principles of consent and compensation, you can place the burden of deciding whether a given community hosts utility scale wind development upon the wind developer rather than the zoning authority. This is as it should be. Now that will become more clear as we talk about the presentation. My point is, wind developers generally like to propose language that's an either or, and that then the commission is trying to decide, half the people don't want it, half the people do, how do I split the baby in half? Well, the other side is that we know in Michigan that when townships get a chance to vote on these things in the manner of a referendum, they typically do not support wind. We've seen margins from 55% opposed to wind to as high as 71% with a Duke project in Hillsdale County. Michigan has a lot of experience with wind now that we didn't have when this project came to my doorstep in 2008 and 2009. We now have 1,000 megawatts of wind turbines installed. And over time, we've changed a lot of our approach on these things. Initially, the state recommended, these were not binding guidelines, but they recommended 1,000-foot setbacks from homes and 55 decibel noise limits. But experience has been a harsh teacher. Every major wind development in Michigan has produced widespread complaints, legal and political action regarding wind turbine noise. We've had recalls, referenda across the state, many lawsuits. I have a map there showing a number of them. I point out in particular this one in the Garden Peninsula. There's only 14 turbines there. The entire peninsula is a migratory bird pathway. The Fish and Wildlife Service said that we do not recommend you build any turbines there because we want a 3-mile shoreline setback from the Great Lakes to protect migratory waterfowl. Nonetheless, those 14 turbines did go in. They defied the Fish and Wildlife Service, which does not have binding authority. So we've only had 14 turbines, but those 14 turbines have resulted in 73 people signing a petition saying, please turn them off. We can't sleep anymore. I'd like to say this is unique or novel, but unfortunately it happens all over the place. In this place, they cited some of the turbines as close as 800 feet to people's homes. It's the only installation in the state of Michigan that I'm aware of that has, where people can hear the turbines over their television. That's unique. Most times they can feel at night low frequency noise and they can hear it during the windiest times, but here these people routinely hear it over their television. As a result of these things, and I was invited by the governor to participate in a series of energy roundtables he hosted across the state, and I regularly testify in front of the Ohio Senate and House, as well as Michigan Senate and House on renewable energy, both economic issues and land use issues. I've also been to DC to testify before members of Congress. Our latest report now, you can see how far we've changed our position. The state references now data that suggests 1.25 mile setbacks and noise limits below 40 decibels. That's what happens after you actually get 1,000 megawatts of wind installed in your state. You realize the claims that the developers make are like the claims of many developers, whether you're building wind turbines, schools, factories, or adult bookstores. Everybody paints them in the finest light because, of course, they're committed to return on investment. We've learned another thing, and I'm going to talk about a couple of these issues, even though they're not directly land use issues, because they often come up in this context of wind energy zoning. We learned in Michigan that we have a mandate that we made 10% of our electricity from renewables. Well, if you look at the wind map, you'll see that Iowa, which is in our same regional transmission operators location, MISO, you guys are in PJM, at least parts of Kentucky are, I think, that Iowa has 8.5 meter per second wind and Michigan has none. And what the bottom line result of that is wind energy in Michigan costs on average $79 a megawatt hour after federal subsidies worth 35 bucks. Iowa wind can be bought for $30 a megawatt hour. So if you like renewable energy and you believe it's going to significantly reduce emissions, you have to ask yourself, why should Michigan buy only 1/3 as much wind energy for every dollar as what they could have imported from Iowa? It doesn't make sense. But worse, in Kentucky, as you know, your best wind is Michigan's worst, just like Michigan's best wind is Iowa's worst. The wind energy here would be very expensive, no question. And they talk a lot about newer turbines. Well, you see this paper, I think it's from NREL, and they report the PPA prices over time, starting here in 96 all the way to 2013. So technology improved a lot in turbines over time. Well, the purple line is Minnesota and Iowa, and the yellow line is the Great Lakes. And you see, no matter what the stage of technological advancement is with bigger rotors and low wind designs, Michigan's wind still remains very expensive compared to our windy states. And Kentucky's, I gotta believe, it's going to be up here. It's a bad value for people who are concerned about protecting the environment. And the final thing we learned from Michigan is Michigan has now spent $2.5 billion building wind and transmission in the state. At most, that could have reduced our coal plant emissions by a couple percent. Had we spent that same money on combined cycle gas turbine plants, we could have closed approximately 1/2 of the coal plants in the state of Michigan. Gas doesn't emit mercury or fine particulates, and it emits half the CO2 and far less sulfur dioxide and so forth. The same money, we could have cut our emissions by half already today instead of only a few percent. If you're an environmentalist, you have to look at this regionally and say wind is an appallingly bad deal for the environment. Secondly, finally, the land use issue is significant. You may not like nuclear energy, but here's a 1,000 megawatt reactor near Detroit, between Detroit and Monroe, 1,000 megawatts. And if you wanted to get rid of nuclear energy and replace it with wind, you could do it. You'd have to build 2 Vestas V100 turbines in every square mile in that semicircle from Toledo to Detroit to Ann Arbor. But you'd also have to build 2 natural gas plants for July and August and all the high demand times when wind was typically not available on the grid. For that much money to build that many turbines, you could replace almost every coal plant in the Midwest with combined cycle gas. It's an appallingly bad deal. Further, 36 square miles of wind like this, as perhaps they proposed in your area, looks like they generate a lot of electricity, but what if I told you that those turbines across an entire township produce the same amount of electricity as this semi-trailer mounted gas turbine that you can hide inside your average dairy barn? If you're concerned about ag land preservation, you have to scratch your head and say, is this really a good return on our dollar? Now let's get to the strictly zoning questions. How do we evaluate any product brought before us? We evaluate the total cost of ownership. We want to know, what's this thing cost, what are the pluses, what are the minuses, and when you do the math, what's left? Well, guess what? It's pretty easy with a car. We know a lot about cars. We're familiar with them, we drive them, we have our opinions on German, Japanese, American, etc., 4-door, 2-door, it depends what you're trying to do. You need a 1-ton pickup, etc. Figure out how much we want to spend, and then we do the math and say, what's it going to cost me over 10 years? Does the cost and the benefit outweigh the cost? That's easy. But when somebody shows up and says we want to build some 100-meter class Vestas V100 turbines, we now have to ask questions about products that we're not familiar with, because like me in 2008, you guys don't have 1,000 megawatts of wind that you can go look at easily in your community. We had to drive a long ways to get these answers. Well, 476 foot tall is the same turbine photo that Mike McCann showed. Those are my friends, the Schindelbeckers that live there. That turbine is at 1,139 feet. They sleep in their basement now at night. In fact, their boys came home for spring break and couldn't stay in the house. They had to stay elsewhere. So let's get our legal guidance here. Again, I'm not an attorney, but we know that Kentucky zoning law, like most laws anywhere in the country, require elected and appointed officials to hold paramount protecting the health, safety, and welfare of their people. If the proposed activity, in my words, cannot be performed in our communities in keeping with health, safety, and welfare, it must not be permitted. And like developers of all stripes, I'm not singling out wind developers, their primary commitment is to bottom line, and their recommendations are designed to maximize the return on investment. But a planning official's single commitment must be to health, safety, and welfare. I didn't know this until the wind issues showed up in my community. I tried to do what the other commissioners did. I didn't really understand completely what our purpose was. Once this issue showed up, like, wait a minute, there really is a rhyme or reason behind what we're doing, and health, safety, and welfare has to be first. The Planning Commission is the only line of defense between irresponsible development and their citizens. It's a sacred trust that you raise your hand and sworn oath to defend. So you have to have a rational relationship to protecting health, safety, and welfare, and you cannot write arbitrary or capricious zoning laws. If you stay inside those bounds, you have an incredibly strong case in court. Good zoning that has a rational relationship to health, safety, and welfare and is not arbitrary and capricious is virtually impossible to overturn in court, which cuts both ways. If you want your wind project to happen and they write a strict ordinance, you can sue and will likely lose. that if you write a permissive ordinance and you are opposed, you will likely sue. And the zoning has tremendous benefit of the doubt in the eyes of the court. Reasonable zoning is strong. You do not have to be afraid about writing zoning that you think represents the will of your people and protects health, safety, and welfare. Secondly, I won't spend a lot of time on this because I think you guys are already considering a conditional use, but I think a conditional use is the appropriate use for wind energy zoning because it's a unique use. It's far different than most other usages that you encounter, like a dairy barn or a small factory or something. It gives an additional layer of accountability for the developer before the zoning authority and allows further public input. I think it's a valuable thing. I won't bother to read all of this from the Kentucky law, but I think if you were to go back and review the slide, you see it defines wind projects very thoroughly. Health, safety, and welfare, protecting that is our sworn duty. Developers of any type are crafty and present many superficially enticing arguments and promises, but protecting health, safety, and welfare must come first. So here's a couple questions and a couple things that you often hear. So let's say, are the developers' profits more important than health, safety, and welfare? Are promised and alleged increases in tax revenue more important than health, safety, and welfare? And I will tell you that in the thumb of Michigan, I have a map of my state, and maybe you don't, but in the thumb of Michigan, the developers showed up and they built a lot of turbines there, and they sold the whole thing on taxable value and how much tax revenue we're going to pour into the state. As soon as the turbines were in, every turbine, one at a time, is appealed to the state tax tribunal. They're challenging the valuations at every step, and they're not getting the money that they promised. It's become a big problem to the point that the most pro-wind development county in the state is now really having second thoughts about this. Our claims of private property rights more important than health, safety, and welfare. Our claims of green jobs or emissions reductions more important than health, safety, and welfare. The short answer is no, they are not. That is what we've raised our hands and sworn an oath to defend. You should also recognize that it's the health, safety, and welfare, not health, safety, or welfare, that commissioners are duty bound to protect. Too often, health and safety are diminished in exchange for promises of jobs or tax revenue and welfare. But those promises of taxes and so forth are not binding contracts. It's funny, once the project is built, how things change. There are many impacts associated with wind turbines. Mr. McCann spoke about property value. I'm just going to focus on a couple things: noise, setbacks, and decommissioning. We could talk about a lot of other things, and I don't think it's necessary. I try to use sources here that are credible and that are hard for you to accuse me of picking anti-wind sources. So first, I picked Vestas, the second largest turbine manufacturer in the world. Their health and safety manual for their employees says, this is for the 494-foot class turbines, if runaway operations should occur, the plant must be evacuated immediately by running upwind, and access to the surrounding area in a radius of at least 500 meters must be restricted. That's 1,640 feet. That's the same turbine you saw with Mr. Schindeldecker's home that's 1,149 feet from the house. That means their employees would have to run 500 feet past the Schindeldecker's home to get to the safety radius. But Vestas is not alone. Nordex has a similar manual. It says in case of a fire in the nacelle or on the rotor, parts may fall off. In case of a fire, nobody is permitted within a radius of 500 meters from the turbine. My advice is that at bare minimum, 1,640 feet should be the distance to anything for the 500-foot class turbines for a participant's house or non-participant's property line. And we see in real life that turbines do fail. This is a 390-foot class turbine, and that debris field that was reported to me to be at 1,500 feet distance. So the manufacturers know what they're talking about. Here's the tricky part. Here's where everybody finds the contention. You have two farmers, Farmer A with no contract with the wind developer and Farmer B with the contract. The typical zoning proposed by the wind developer wants to measure those setbacks from the home. You see what happens is, and you've probably already thought about this, in this semicircle over here, I'm sorry, my handshakes, that neighbor has just taken from you your future development rights. The wind developer was awarded that semicircle to use as a nuisance and safety easement for free as a result of the zoning ordinance that they recommend. That's not reasonable. Secondly, you can see, you could have your children's swing set inside that radius. And if you have a turbine failure, like we're seeing more of, they're now inside that safety perimeter. Can you imagine your kids playing in the same yard where the employees have to wear a hard hat, steel-toed shoes, and protective eyewear? What is reasonable, and our municipal attorney we consulted with in our township recommended all the setbacks be measured from the property line. I know of no other land use regulation that's ever measured from an interior feature of the neighboring parcel. It's always from the property line, setbacks, percentage of coverage, etc. Now the farmer with no contract can safely build at least within that minimum diameter on all of his property. And you say, well, I have a right to do what I want with my property. Oliver Wendell Holmes was clear. The right to swing my fist ends where the other man's nose begins. Our private property rights only extend so far as to the point where we begin to cause harm. My corollary is if my development project requires me to repeatedly punch you in the nose, I should first get your consent and then compensate you for your broken nose. Riga Township chose 5 times the height of the turbine to non-participating property lines and a quarter mile to a participant's residence with the larger setback reducible with a waiver. So that worked out to about a half mile to the property lines. Now, because of what the state has come out with their latest data, I think I would recommend 10 times the height to non-participants and 1640 to participating homes just because of the turbine manufacturer's data. The whole setback arrangement with the waiver now takes the responsibility from saying yes or no to that development away from your planning board and your county commissioners and places it firmly in the hands of the citizens, and it compels the wind developer to negotiate with everybody inside the impact zone instead of just a few large landowners. That strikes me as eminently fair and reasonable. It is important for the setback to be at the property line because, again, otherwise you're awarding an uncompensated nuisance and safety easement by means of a zoning ordinance. That doesn't seem reasonable to me. We're supposed to protect health, safety, and welfare, not award it for free to a developer. The 2-stage setback is what empowers the citizens to decide for themselves what they want their neighborhood to look like. It prohibits wind developers from leasing in a checkerboard fashion. It requires them to negotiate with all residents. Now, how loud is too loud? This gets contentious quickly, and again, I try to go to sources that anybody could recognize as being valid. The World Health Organization recognizes, without going into detail, that below 30 decibels is pretty much safe at night for everything. Between 30 and 40 for a nighttime average, you start to have some impacts, but people start to stir and you can have some awakening. But young people and chronically ill people can be more affected. Between 40 and 55, the World Health Organization says you now have a sharp increase in adverse health effects. And above 55, it's frequently even suggests evidence that the cardiovascular system is stressed. Now, mind you, wind developers are still receiving in some parts of Michigan, in various townships, permission to go up to 55 decibels, but in general, we're trying to keep it at 45. But what if we ask the American Wind Energy Association's noise expert? He once tested, wrote in a paper that 45 dBA LEQ would not cause adverse health effects, but later he gave some testimony and he said if it was his house, he would like the turbine noise to be kept below 35, something along those lines, maybe 40. Dave Hessler is an acoustic engineer, acoustic consultant. He works with a lot of wind developers, but the state of Minnesota hired him, retained him to do a study on wind turbine impacts, and he said, look, based on the observed reaction to typical projects in the U.S., it would be advisable for any new project to attempt to maintain a mean sound level of 40 dBA or less outside all residents. It is important to note that a project sound level of 40 dBA does not mean the project would be inaudible or completely insignificant, only that its noise would generally be low enough that it would probably not be considered objectionable by the vast majority of neighbors. Rob Brand, an independent consultant, looked at the Riga Township ordinance and said, look, 45 dBA and 1,300 feet, experience in New England has proven that these noise levels are associated with widespread complaints, appeals to stop the noise, and legal action. But how about the manufacturer of the turbine themselves? Vestas also recommends that governments supplement relative noise limits with a low absolute maximum areas of very low background noise, like a quiet countryside like I experienced here last night. It ensures minimal noise disturbance for turbine neighbors also in these places. That means, and again, I suggest that the commission retain a qualified acoustic consultant because you tread on thin ice. It's a very technical science. But that means LA max, not LEQ, and I'll show you the difference. LA max is like a speed limit on the expressway. You're doing 70 in a 65 zone, and you can't say, yeah, but my hourly average was 63, officer, so you can't write me a ticket. That's what LEQ is. It's an hourly average. LA max is a fixed hard limit. It makes it much easier to enforce. And I'll tell you why the wind developers like to do this. They like to say, we'll do a LEQ, or an hourly average measurement, to establish your nighttime noise, your ambient noise, or your residual background noise. Well, here's how it works out, and I don't pretend to understand this formula. But the bottom line is, if the noise consultant measures 59 minutes in your community of 25 decibels, so 59 out of 60 minutes is 25, that's very, very quiet. And then a car drives by for just 1 minute at 65 decibels, the hourly average was just raised to 47.24. So when they come in and say our turbines will only be 45 decibels, which is no louder than what you're experiencing now, in truth, 59 out of 60 minutes, you may only be experiencing 25 decibels. Yet the turbine is now permitted to operate at 20 decibels or more, louder than what your normal nighttime noise is. So, you know, as they say, figures lie and liars figure. You have to be very careful that your consultant is working for you. We adopted a 40 decibel nighttime noise limit at non-participating property lines and 45 daytime. It was a compromise. We also added, and I think this is important, like Vesta said, a low frequency noise limit. We recommend 55 decibels C, DEC, which includes the frequencies below 20 hertz for low frequency noise protection. I think these are a reasonable compromise with developers' desire in health, safety, and welfare. Stop the flicker. 30 hours a year is what they asked for. I would say it's very hard to enforce an ordinance that requires somebody to measure the flicker events outside their home for 365 days before they can file a complaint. I'm not sure how you do that. There's modern software and detector packages available now that they mount the sensor on the home when it's detecting a flicker event, it stops that turbine. On overcast days, the developer would actually have more siting flexibility because you won't get any flicker when it's overcast, but on the sunny days, it would actually stop it for the 20 or 30 minutes a day that would be a problem. When developers always say as technology improves, the impacts will lessen. This is a great way to hold them to that. Finally, decommissioning matters. These are the abandoned turbines in Hawaii. I assume there was no decommissioning bond. It's obvious the scrap value was not high enough for them to have come in and removed them, or they would have done that. I heard a developer tell me in northern Michigan once that you don't need a decommissioning bond. They're easy to take down. You loosen the bolts and set dynamite at the base and they drop like a tree. I recommend the county require a decommissioning bond and the value be determined by an independent third-party engineer selected by the municipality and paid for by the wind developer. The developer often recommends a financial guarantee. That's not recommended, and here's why. This is a chart from Next Era's seminar they did on the finances of wind turbines, and if you look, in the first 10 years, the bulk of the value is taxes and not cash. And what that means is generally, it's called the Minnesota flip, and you can read more about that, but the typical wind developer only owns this project for somewhere between 7 and 10 years. So Next Era and Florida Power and Light, they're a large Fortune 200 company. They're financially secure, but the next owner and operator is not likely to get the production tax credit, and secondly, he's going to have a depreciated out turbine. How are you going to make sure that a financial guarantee from Joe Blow Wind is actually going to be enough to make sure that things are removed when you're done? The entity you are negotiating today will almost certainly not be the entity that owns the project at decommissioning time. We may discover that here. I mean, I saw the news report that Duke has said they're not going to move forward here. Next Era could very well buy those leases. We saw that in Michigan. Our oldest project in Ubley, Michigan is now on its third order since 2007. That project has people living in their basements there and renting apartments in the next town as well. So what do I recommend? I'm wrapping up now. Most land use changes are pretty benign. Lot sizes, setbacks. I mean, if your neighbor is allowed to build 7 feet from his property line instead of 10, the impact might be a little different, but it's not huge. Or if you can have a billboard that's 80 square feet and you change it to 100, you know, it's minimal. But wind turbines impacts are far beyond that. We felt in our township that the change of land use policy was so massive and the impact so profound that they should not occur without consent. And you can't force compensation, but obviously if you require them to negotiate with everybody, most reasonable people will determine for themselves what price they place on living next to turbines. So it's an implied compensation. And I know of one guy in northern Michigan that actually did sign a lease next to Mr. Schimmelbecker's house for $100 a year, good neighbor agreement. They placed the turbine at $950. He calls his house the worst place to live on earth, and he has fled to his cabin in the Upper Peninsula. So be careful. But the other option is to let your commission award your property for free or simply to keep them out. Those are the other options. I like consent and compensation. It's a nice, reasonable solution. 2-stage setbacks with a waiver for both noise and distance required that the developer to negotiate with everybody who's impacted. It's fair and equitable and lessens community division, though, you know, observing things around here, sadly, I see this kind of division everywhere. and it troubles me a great deal. One of the purposes of zoning is to protect the social fabric of the community, and wind developments are more divisive than almost any other land use I've seen, with the exception of a proposed low-level nuclear waste dump that came to our township in the 80s. Conditional use permit gives zoning authority maximum flexibility, protecting health, safety, and welfare. Remember, commissioners, no one has ever come into your commission and said, the light coming through my windows is too steady, could you make it flicker? Nobody has ever said the nighttime noise level is too quiet, could you raise it to 55 from 25? Nobody's ever said my property values are too stable, could you build some 50-story industrial machines next door to put that value at risk? The old rule with zoning essentially is this: as a community, you have the right to say, we were here first, we get to decide. Remember also, developers will never have the right answer to the question of health, safety, and welfare, and this is all developers, when their paycheck depends on not knowing the right answer. And finally, of course, we recognize when it comes to their experts, he that pays the fiddler gets to pick the tune. Wind developers ask communities to basically give away free nuisance and safety easements across neighboring parcels. Reasonable wind zoning demands that those easements be negotiated individually and privately between the developer and the impacted landowners rather than forced upon them by zoning regulation. The wind developer first to place the difficult decision of do we let wind in or not in the hands of the zoning authority. By creating two-stage zoning and setting those limits at the property line, the decision as to whether the project proceeds or not is now in the hands of the private property owners and the developer. If they find the ordinance too restrictive, they can obviously just buy houses out and push them over with a bulldozer. Nobody will be affected. People will have their property value guaranteed. Secondly, they could put in far more turbines in a smaller area, which would probably give them a greater return on investment and will protect far more agricultural land. I don't understand why they don't offer that, except that I think they understand that wind energy is not going to last very long. The subsidies are, Warren Buffett just said it last week, wind doesn't make much sense, but I invest in it because it reduces my income tax burden on Berkshire Hathaway. When that goes away, like it is expired right now, it's not going to continue. I just heard the CEO of Duke Energy say in Columbus at an energy conference that I was at this spring, that said wind makes it very hard for our baseline generation business to continue because it's given priority access and unfair pricing pressure that depresses the value of electricity in the wholesale markets. And you see now Duke is trying to sell its generating assets. And finally, this is the 390-foot classes of turbines in DeKalb, Illinois. It gives you an idea of what those various setbacks look like then. I can only say that it's more profound now. Thank you.
Now, do we have one more expert testimony? Is that correct? Or is that it right here? All right, come to the stage. All right, PowerPoint. Do we need it for this one? He does? Okay, got it.
My name is Holmes. I'm a physician here in Mason County. I practice clinical endocrinology, so I'm an expert in hormone disorders. So you might wonder, why am I talking about sound health issues? I found this a very compelling, interesting subject to look at. And as a physician in the area and as a resident in the area, I thought my role would be to give you as an objective as possible view of what are the known health effects, or if there are any, of wind turbine installations on the population, particularly in the rural area. In the interest of time, after reviewing hours and multiple different studies, internet sites, I'm trying to compile a short presentation that will give you a fair view of what the current state of the art is with respect to health impact. All of the data, quotations, and things that are in this, I've tried to provide reference to at the base. Anything that's in quotations or it's on a slide has been taken from a peer-reviewed study. If it's otherwise, I'll indicate during the presentation. let's define health to begin with. It's one of the key factors that was just discussed. World Health Organization defines health as a state